Good morning and welcome to the Caregiver Teleconnection. My name is Glenda Rogers and I'm going to be your facilitator for today's session with Brennen Boze, who is an attorney in San Antonio, Texas. And he's going to be going over some legal documents and advanced directives that we all need to have in place as we move forward in our lives. And Brennen, why don't you tell everybody a little bit about yourself?
Sure. Hi, good morning, everyone. Like Glenda said, my name is Brennen Boze. I'm an attorney at the law offices of Carol Birch in San Antonio, Texas. We practice what is called elder law, and that's kind of an umbrella term. It covers a lot of different areas of law, but a lot of things like estate planning, which is what we're touching on today. Um, Special needs planning for folks who are on government benefits and may come into an inheritance and need to be able to receive that inheritance without losing their benefits. We do probate that I'm going to touch on a little bit today. It's a complicated topic, but it's what happens after someone dies, the legal process that you go through after someone passes away. And then we do long-term care planning and help folks get Medicaid eligibility for nursing home care. There's a web of complex rules that apply to that. There's often things we can do to ensure that a spouse at home has the funds that they need, that they don't go bankrupt, making sure that their spouse gets the care that they need. So elder law is it's a relatively new area of law. You're probably not going to see us on billboards and buses, but we are out there, and I feel like personally that we provide a very important service. It's a niche area of law, but it's one that is ever growing. As everyone here, I'm sure, knows, the need for caregivers, the need for long-term care, and the need for advanced planning for just the things that happen as we age is ever more important in American society as the population gets older. So with that, I will jump into my PowerPoint. Let me get the screen going. All right. Can everybody see the screen, the PowerPoint screen?
Yes, we can see it.
Very good. Okay. Well, the title of this topic is, or this presentation is, Who Decides When I Can't? And I give this presentation a lot to senior centers, various organizations, but I find it really applies to folks who are caring for someone in this position. A lot of times they're the ones that are driving the bus or steering the ship, and they need help figuring out what they need to do when their loved one, the person that they're caring for, is reaching a point where they can no longer handle their own affairs. And so the biggest thing this is about is really estate planning. Estate planning to most people, in my experience, tends to be, they think, who gets my stuff when I pass away? And that's an important part of it. And we'll talk about that a little bit today. But the other side of the coin is planning for incapacity, planning for that time in our life where, whether it's temporary or whether it may be permanent, we can no longer make decisions for ourselves, financial decisions, medical decisions, things of that nature. Who decides when I can't? And what do you need to get in place to make sure that your loved one's wishes are going to be the wishes that are followed through? So we're going to talk about a number of documents today, a number of legal documents today. Let me pull that up. The first slide. The key documents that we're going to talk about are wills or trusts. That is the first side of the coin, the who gets my stuff after I'm gone. The rest of these documents are things that apply to people that I think everyone needs regardless of age, but is especially important when you're in a caregiver situation or someone needing long-term care. And that's things like financial power of attorney, medical power of attorney, advanced directives that are also called directives to physicians or sometimes living wills. I'll talk a little bit about HIPAA and HIPAA authorizations, and then declarations of guardian. So this is just kind of an overview of the different documents that I'm going to be talking about today, but we'll get into more detail about each of these as we go. So to start with, I'll hit on the topic that most people think of when they think of estate planning. Do I need a will or do I need a trust? And I'm an attorney, and if y'all have ever had any dealings with attorneys, you probably already know the answer, and it depends. It always depends on the unique circumstances of the person that we are caring for, or our own unique circumstances. But the basics of a will and a trust are the same. The basics are making bequests, which is making gifts of your property to loved ones or charitable organizations after you pass away, and then naming someone to be in charge of overseeing this process. If you have a will, that person is called the executor. If you have a trust, that person is called a trustee. Now, if you don't have a will or a trust, you pass away what is called intestate. Intestate means you pass away without a legal document in place. And the biggest thing that happens there usually is unintended consequences. Most of us have good ideas about what we want to happen to our things after we're gone, and it may be very simple. It may be, I want everything to pass to my spouse or to my children. But in my experience, many, if not most people, have more complicated situations than that. And if you pass away without doing any advanced planning, you will have no say in what happens to your things after you're gone, or your loved one will have no say in what happens to their things after they're gone. So there are unintended consequences. One of the biggest questions I get asked as an elder law attorney is, do I need a will or do I need a trust? And the main difference between the two is that wills have to go through the probate process. A will is a document that is enforceable by a court, but no bank or no financial institution or no title company is just going to take somebody's word that this is a valid will. It has to be given to a court and proven up as valid, and that is the probate process. So wills have to be approved by a probate court. And one of the biggest disclaimers I need to make at the beginning of this presentation is that I am an attorney licensed in Texas. I'm also licensed in Arkansas, but the bigger thing is that this presentation is intended to be broad and cover situations that I think apply to almost every state. But if you're in a different state, you need to have yourself or your loved one talk to an attorney in that state, because the requirements are always a little bit different. So when I talk today about legal requirements, I need to make it clear that I'm talking about Texas's requirements. Your state may be a little bit different. I just advise everyone, if you can, if you have the means to do it, it's usually well worth the time and expense of at least having a consultation with a lawyer to make sure that your documents meet your state's requirements. But in Texas, there are several requirements for a will. It has to be in writing. It has to be signed by the person making the will. There has to be 2 witnesses to the will. And those can't be family members or anybody that's set to inherit in the will. They need to be what are called disinterested witnesses, somebody who doesn't have an interest in this person's estate. One of the biggest things I tell people, I'm a lawyer, so of course I'm going to say this, but I truly believe it. Beware of internet forms. You can find free forms for a will off the internet. But like I say, every state has their own requirements. I meet a lot of people who come in after someone has passed away and they say, well, mom did this will online. Here it is. There are no witnesses, or it's not dated, or there is something missing in the will. It doesn't name an executor. And if the will doesn't meet your state's requirements, you effectively have no will. You are going to pass away intestate. So again, I just encourage everyone, if you have the means or ability, there are, and if you don't, there are pro bono services. There are charitable organizations that offer legal services. Research those in your area. At least talk to someone about this, someone that's knowledgeable about your state's requirements, to make sure that the documents that you're doing are going to be valid and enforceable. So the difference between a will and a trust, again, is that a will must go through probate. A trust is a document that avoids probate, but it is a little more complex setup. A trust involves a legal document that's drawn up, but then it involves giving someone who's named the trustee legal ownership of the person's assets. The reason you do that, and often someone will create a trust and name themselves the trustee while they're alive so that they can continue managing their assets on their own. But because you give it to a trustee and the trust is holding the person's assets now, a trust never dies. And so a trust doesn't have to go through probate. The problem is that this often gets complicated. It involves retitling assets. If someone owns a home, we have to deed their home to the trust. So again, it depends on the person's unique situation. If they have an interest in a corporation or an LLC, they have properties in different states. Maybe you have a blended family and you want to keep your assets separate from your wife's assets. A trust can be more effective than a will. But again, talk to someone and find out what's right for your or your loved one's unique situation. That said, some assets can pass outside of a will or a trust, and these are called non-probate assets. The biggest example I can think of is life insurance. Usually when someone takes out life insurance, they name a beneficiary. And that beneficiary form, where you're naming someone who is going to get the proceeds of your life insurance after you pass away, that's a contract with the life insurance company. And they say, we're going to honor that contract regardless of what your will or your trust says. You have this signed agreement with us. And when you pass away, we're going to give the money to the person that you have designated. So life insurance is what's considered often a non-probate asset. Bank accounts, IRAs, lots of different financial instruments, you can designate a payable on death beneficiary and avoid probate that way for those assets. But I don't want to get too deep in the weeds because wills and trusts are important. But most people have in mind, usually in my experience, something that they want to do or some plan in place for what should happen to their things after they die. Incapacity is the larger problem that we run into. And so the rest of these documents that I'm going to talk about are about planning for incapacity. The most important document that a person can have to effectively plan for a period or a lengthy period of incapacity is a financial power of attorney. And in Texas, that's called a statutory durable power of attorney. A power of attorney is a document that lets someone speak on your behalf. What this does is it allows you to appoint a person or your loved one to appoint a person to handle their finances in case they become incapacitated. If there's a stroke, if they develop dementia or Alzheimer's and can no longer handle their finances, someone can step in and access bank accounts, access their funds to make sure bills get paid, to make sure that the ball keeps rolling. And sometimes, especially if there's a need for long-term care, making sure that there's an ability to pay for long-term care. The biggest question that clients asked me about financial powers of attorney is that, hey, I'm not ready to give up control of my finances yet. And the answer to that is that a power of attorney does not take any rights away from the person making it. All it does is designate someone who can speak on your behalf if you're not able to. So you can execute, or your loved one can execute, fill out, and sign a power of attorney and still have full control over their own finances. The power of attorney is designed to make sure that when you can no longer do that, someone can step into the breach. A financial power of attorney is a complex document. In Texas, it's called a statutory power of attorney because there is a specific statute or law that says what it should look like. So it is usually a form document, but there are a number of choices that you make in that document that decide how broad or how limited the power of attorney is going to be. You can give somebody the power to access your bank accounts, but not sell property on your behalf, sell your home. Usually for my clients, I recommend that you make a power of attorney, a financial power of attorney, as broad as possible. And that sounds scary to a lot of people. It's a scary thing. You're giving somebody complete control over your assets while you're still alive. But if there's a real concern about the person that you are designating to be your agent under the power of attorney, you usually need to find a different person. This is a relationship that involves a high degree of trust. Usually we want a power of attorney to become effective immediately upon signing. And again, that may seem counterintuitive too, because a lot of people tell me, I don't want anybody to be able to touch my finances until there's that emergency that happens and I'm in the hospital or I have dementia and I can no longer do it myself. I don't want anybody touching my things until then. And what I normally tell people is that that sounds good in theory. That's what, most people would want, all things being equal. But if your power of attorney only becomes effective upon incapacity, it often leads to some unintended consequences because incapacity has to be determined by a doctor. And if there's an emergency situation, let's just say there's a car accident and mom is in a coma now, and you have to go find mom's power of attorney, and it says that it only takes effect if mom can no longer make her own decisions. Well, a bank is not going to honor that power of attorney until you get a note from a doctor certifying in writing that mom can no longer make her own decisions. And maybe in the case of a car accident, that's relatively easy to do. She's in the hospital and the doctor's willing to sign off on that. But in my experience, doctors don't like signing legal documents. They don't like being put in the position of having to make that determination. Maybe the general practitioner, mom has dementia, and the general practitioner says, I'm not a neurologist. I can't make that call. Well, now you have to wait for a neurologist appointment. That can take months. And even if you get in front of the neurologist, maybe mom's having a good day and the doctor doesn't feel comfortable signing off on the power of attorney. I see this happen all the time. And when it happens, it's usually a crisis for the family because mom has medical bills, she has care needs, there may be a mortgage that needs to be paid. And we don't have months to get in front of a doctor, in front of the right doctor on the right day to get something in writing. So I encourage my clients to make their powers of attorney effective immediately and pick someone that you have a high degree of trust in. If you've got that son or daughter that's a CPA, maybe that's the right person to step in. It doesn't have to be someone with expertise. It just has to be someone who knows how you or your loved one handles their finances, handles their own affairs, and is willing to act in that same way, willing to honor the person's wishes. So that's the financial power of attorney. And I'll talk about later what happens if you don't have some of these documents, because that's when things really get scary. So most important thing I'm going to talk about today, in my opinion, is the financial power of attorney. In Texas, that's statutory durable power of attorney. The other side of the coin is not just financial decisions, but medical decisions. Let's say your loved one is incapacitated, they have dementia, advanced dementia, and they need surgery. Well, if you've ever been in a medical setting, you know that doctors need consent before they can approve of procedures. That consent is usually given by the patient. But what happens if the patient can no longer speak for themselves? That's where a medical power of attorney comes in. A medical power of attorney is just like the financial power of attorney. You're giving someone the ability to speak on your behalf. But unlike the financial power of attorney, the medical power of attorney only becomes effective when the doctor certifies that you're incapacitated. And that makes sense in a medical setting. If a doctor's determining whether or not to perform a procedure, Mom is right there in front of the doctor. The doctor is going to be able to certify whether or not mom can speak on her own behalf. So it's not the same situation as the financial power of attorney, where it may be more of a gray area. But the biggest thing I tell my clients is that medical decisions, you make your own medical decisions until you no longer can. If you even can't speak, but you can give a thumbs up or a thumbs down to the doctor's going to listen to you or your loved one. Only when that you're past that point and can no longer make those decisions will they look to the medical power of attorney. So power of attorney, again, in Texas is split in two. In my experience, that's true in most states. There is a financial document and a medical document. You can pick the same person to make those choices for both documents. It doesn't have to be different people, but it can be. Maybe one child is a nurse and one is a CPA. Well, then the CPA could be the financial power of attorney and the nurse could be the medical power of attorney. But again, neither one of these require detailed expertise. You don't have to appoint your lawyer as your power of attorney. You just need to appoint someone who is going to honor your wishes and knows how you handle your affairs, knows your beliefs about medical treatment. The next major document that I advise all of my estate planning clients to have to plan for incapacity is what's called a directive to physicians in Texas. In other states, it's called simply an advance directive. The common term I hear for it is a living will. And what this document is it allows you to tell your physician in advance when you are at the end of life, when there is nothing the doctor can do to bring you back to health. All they can do is artificially prolong your life. They can put you on a ventilator to breathe for you, or they can put you on a feeding tube to give you nutrition. Many people have strong feelings about those kind of situations. What I always go back to is the situation that was in the news. Gosh, it's probably been 20 years ago now, but Terri Schiavo. Terri Schiavo was a woman in Florida who became incapacitated at a relatively young age. And she was married and she had her parents. And there was nothing that they could do to bring Miss Schiavo back to health. Her body was failing, but they could keep her alive indefinitely. And her husband told the doctors, my wife would never have wanted to live this way. My wife would not have wanted to have machines breathe for her and have artificial life support keeping her alive. But Miss Schiavo's parents believed opposite. They thought that their daughter should be kept alive as long as possible. I mean, miracles happen, medical miracles happen. People come out of comas after years. There's no right or wrong answer to this question. It's a question of what your or your loved one's belief is. How do you feel about being in that situation? If at the end of your life, do you want to be on breathing machines? Do you want extraordinary measures taken to prolong your life? Or would you rather just have what's needed to keep you comfortable and let you pass away gently? What the directive to physicians does is it allows you to make that choice in advance so that your loved one is not having to make that difficult decision and is not having to carry that difficult burden. But again, a directive to physicians or an advance directive / living will, it's not what many of my clients think. It's not a license to pull the plug. It only comes into play in really narrow circumstances. And again, what I'm about to say applies really only in Texas, but I suspect that if you're in other states, the laws are fairly similar. In Texas, a directive to physicians only comes into play if the patient can no longer speak for themselves. They have been deemed incapacitated. Again, if you can tell the doctors what you want, they're going to listen to you and not look at a legal document. So you have to be incapacitated on one hand, and on the other hand, you must have either a terminal or an irreversible condition. And that means there's nothing they can do to bring you back to health. It is truly an end of life situation. It can be treated but not cured. And without life sustaining treatment, without that ventilator, without that feeding tube, the person is going to pass away. Or a terminal condition, even if we put you on a ventilator, death is imminent within the next 6 months. There is nothing that we can do to bring you back to health. And so I say that to people to make them a little more comfortable with this document, because it's a scary decision to make. Many people have very strong beliefs about this and are ready to sign off on, I don't want to be put on a ventilator at the end of my life, but others are understandably concerned. And so I say this to show that this only really applies in limited situations where there is nothing that can be done medically to bring someone back to health. Now, the directive to physicians often gets confused with the next document that I'm going to talk about, and that's a DNR. A DNR is kind of the flip side to the coin. An advanced directive, or a directive to physicians, is a situation where you are alive but dying. Do we want to keep you alive in that terminal or irreversible state? A DNR is a do not resuscitate order. It's the other side of the coin. You have stopped breathing, or your heart has stopped. Do you want the doctors to take efforts to bring you back to life after your heart has stopped or you have stopped breathing? Now, a DNR is not, at least in Texas, is not a legal document. It's a medical document. You don't get this from your lawyer. You get this from your doctor, and a doctor has to sign off on it. A DNR covers immediate, specific medical procedures, things like CPR, tracheotomies, defibrillation, where they have the paddles and shock you back to life. Many people in an advanced state of dementia, or just an advanced stage of life, don't want to be brought back if they have legally died. And this document, again, is designed to take a difficult choice, a difficult burden off of your family. So again, flip sides of the same coin. Directive to physicians, you're alive but dying. A DNR, you have effectively died. Do we want to bring you back to health? So those are the main documents that I'm going to talk about. Let's talk about what happens if you don't have these documents. So let's go back to the financial power of attorney. If someone doesn't have a financial power of attorney, what you're going to find out is that if their bank accounts are not joint, if there's not a cosigner on that account, if that's mom's bank account and nobody else's, the bank is not going to deal with anybody else. Nobody is going to have access to those funds. This is extremely important in the long-term care setting, where your mother or your loved one may need nursing home care. Long-term care is extremely expensive, and there's often not a lot of help from the government or pro bono agencies to pay for this, and so people are required to pay out of pocket. If you don't have a financial power of attorney, families are going to find it's extremely difficult to pay for long-term care, and it will often fall upon the family to come up with the funds or seek guardianship. And guardianship is kind of the break glass in case of emergency option, where someone has not done any advanced planning. There is no power of attorney in place, but things still have to be paid for, and we have to access mom's IRA so that we can pull from it to make sure that we can pay the nursing home next month. It also comes really into play if they need long-term care Medicaid. Medicaid is the only government program, at least in Texas, that pays for nursing home care or long-term care. But Medicaid is a program that is designed for people with very little, and it requires people to spend down their assets until they have very little before they will qualify. Well, mom may only have $10,000 to her name, but that may keep her from qualifying for Medicaid. And if there is no financial power of attorney in place, there's going to be no way to spend that $10,000 down to the point that mom is eligible for Medicaid. And so guardianship may be the only alternative. And I'm going to talk about what that looks like here in a little bit. But this is why I say the financial power of attorney is the most important document that someone can get into place, because not having it often causes a lot of strife. It will always cause a lot of stress, and it often costs a lot of money because guardianship is a long and arduous procedure. What happens if there's no medical power of attorney? If there's no medical power of attorney, then in Texas, at least, the law says who speaks on this person's behalf. It lists family members in a certain order of priority. Your spouse may be able to be the one to make medical decisions, or your reasonably available adult children. And maybe that's okay for most people, but is it who you want? The biggest thing is that it's out of your hands. It's out of your loved one's hands. They don't have the choice to say who is going to speak on my behalf. The law is going to pick someone for them. And the other situation I see often is what we call elder orphans, seniors who do not have close family around, do not have that support structure. The law may default to someone making decisions for them that hasn't spoken to them in 10 years. So again, the medical power of attorney allows you to pick someone, or your loved one to pick someone in advance who can make these decisions for them, someone that they trust. Maybe they're estranged from their family and they have a friend from church or a neighbor who has been taking care of them for years. It doesn't have to be a family member. It just has to be someone who you or your loved one trusts to take action in the same way that you would take action for yourself. What happens if there's no directive to physicians? Again, in Texas, the law says who makes the decision whether or not to put mom on artificial life support or not. And if there's no family around, then the doctor may end up making the call themselves. Now, for many people, that may be okay, but I find talking to people about these issues regularly that most people would rather have some say in the process. And without getting these legal documents in place, you're not going to have any say. Same thing with the DNR. If there is no do not resuscitate order in place, then they're going to ask the medical power of attorney to make a very difficult decision. Should we resuscitate your loved one whose heart has stopped? If there's no one around, then a doctor may make the decision themselves. Again, it's out of your hands. So the idea of these documents is to have something in place so that you, the patient, are speaking on your own behalf through these documents and through these people that you designate. But getting the documents in place is just the first step. If you have a loved one who is facing dementia or looking down the road at potential incapacity, how do you help them choose someone who could speak on their behalf? Choosing an agent involves finding someone that you trust, that would be willing to act upon your wishes and separate their feelings and their beliefs from the patient's. One of the things that a lot of people come to me and ask is, well, I've got 2 kids. I want to name them both my agent. I try to get people to steer away from that for a lot of different reasons. One, because if you name 2 people in your financial power of attorney, then the bank or the IRA company is going to say, well, we need both of those kids to sign off on every document. And maybe one kid is out of state. And so it's difficult just practically to get everybody on the same page. And then the other thing that no one likes to think about, everyone tells me, my kids get along great while things are going good. But in an emergency, tempers flare, emotions are high, people's beliefs are different, and people believe different things and have different ideas about what mom would want in this situation. And if two people are given equal authority under the law to speak on mom's behalf, who's the doctor going to listen to? Again, there's dangers in appointing two people. So I try to stress, pick one person to be in charge of these issues. This is not a gift to your family in the sense of I am letting you be my power of attorney. It's a job. I am asking you to speak on my behalf when I no longer can. So in preparing these advanced directives, other things to consider: is this person nearby? Could they travel to be at the patient's side if needed? Is it someone who's willing to have difficult conversations? I am an attorney that talks about these things every day, but I know that this is not a fun topic. I know that this is not something people like to get around the dinner table and talk about. What should happen if I am dying, but do I want artificial life support? But in choosing an agent, in choosing somebody who's going to speak on your behalf, it needs to be someone who's willing to have these difficult conversations and willing to listen to you and willing to act on your wishes. And then the other thing to consider is who's going to be available, because these powers of attorney, you may come into my office when you're 70 years old, but it may never come into play until you're 85. And if you've picked someone, you've picked your brother who is about your age, your brother may be gone in 15 years, or your sibling, or your parent. So we want to have somebody on there. It may not be the first choice. Maybe your brother is the first person who should be on the power of attorney for now, but we want to have backups. We want to have someone at least on there that may be available long into the future. So these are all things to consider when you're filling out these forms. Now that you've got them, let's say you've talked to your loved one, they have met with their lawyer, or they have gone online and done their research and gotten all these forms together. Now what? Well, one, the agent can't use them if they don't know where they are. So make sure that you have the documents somewhere accessible to the agent. And by agent, I just mean the person who is speaking under the power of attorney, the person that's designated under the power of attorney. I think a good idea is to give copies of the medical directives to the agent in advance. Now, maybe not the financial power of attorney, because again, the financial power of attorney is often effective immediately. So you say, here's a copy of my medical power of attorney. If the doctor needs someone to speak on my behalf, you can show them this document and do it. But if I need help with my finances, it's in the safe in my bedroom, and the code is on the back of the safe. Make sure that the agent has access to it. Let them know where to find the originals in case of emergency. It's not a bad idea to give copies of your medical directives, the medical power of attorney, the advanced directive, and the DNR to your regular doctor or to the caregiver so that they're readily accessible in case of emergency. So just getting the documents in place is not the end of the road. One of the other things I tell my clients is create a little worksheet. You don't have to write down every dollar that you have in the bank, but again, your financial power of attorney, if you need or your loved one needs nursing home care and we need to access their funds to pay for it, the financial power of attorney doesn't know necessarily where you bank or where your IRA is held. So I have my clients usually write up a little worksheet. I have a checking and savings account at Frost. I have an investment account with Edward Jones and an IRA through Fidelity. So at least they know where to look, because in an emergency, accessing funds is often really, really important. And there's not just a database that I, as a lawyer, can plug in somebody's social security number and say, oh, just go to Chase Bank, and that's where your mom has her accounts. It's incumbent upon the person filling out these documents to let their agent know where to look. So just getting the documents is step one. There's other steps involved, making sure they know where to find it and making sure they know where to look for finances. So in the background of everything I've talked about today, there has been the specter of guardianship looming. If there are no documents and there is no advanced planning done, then guardianship may be the only alternative. And guardianship, I'm going to kind of just quickly run through what that looks like, just to give you an idea of what a family would face if there is no advanced planning done. And by guardianship, in some other states, they call it conservatorship. So that's just another word for the same thing. If you're in California, I'm talking about guardianship, but in your state, it's conservatorship. Two words for effectively the same thing. Guardianship is a measure of last resort. It is expensive and time consuming. It is a court process. And if you've ever been involved with the courts, you know that nothing is done overnight. This is a long-term plan and a long-term process. If you'll remember when I was talking about the powers of attorney, I said that it doesn't take any rights away from you. It just lets someone speak on your behalf. Guardianship does take away your rights. A guardianship is where a court says you are incapacitated and you are a danger to yourself or others. We have to take rights away from you. In a guardianship, the person who is the subject of the guardianship is called the ward. And if guardianship is granted, they are no longer going to have the right to vote or drive or decide where they live. The guardian that's appointed is going to be able to make those decisions for them. You want to avoid guardianship through careful planning and discussion with your family and getting these documents that I've talked about today in order. But sometimes guardianship is unavoidable. And even if you get your powers of attorney in place, what about that situation where mom names both of her children as the financial power of attorney, and the two children don't get along or don't see eye to eye about what should happen? The bank is going to throw up their hands and say, if you two can't agree, then we're not doing anything until a court tells us what to do. So again, that's one of the dangers of naming multiple people to be your power of attorney. It may lead to guardianship if they can't see eye to eye. What does guardianship look like? It's only granted if the ward is incapacitated. In Texas, a guardian is appointed to handle personal matters. That's called the guardian of the person. And financial matters called the guardian of the estate. And I'm just going to speed run through this so that we have time for questions. But the long and short of it is that it is a long and winding and expensive road. It requires you to hire a lawyer. The court, because they're going to be taking rights away, is going to pull out all the stops to make sure that there are no less restrictive alternatives to guardianship, that there's nothing else that can be done as opposed to guardianship. And that takes time and it takes money. The court's going to appoint a separate attorney whose job is just to represent the ward, to make sure that the family is not exploiting them. And then even once guardianship is granted, the process doesn't end there. You have to go back to court to request expenditures. You have to report to the court every year about the ward's well-being and account for every dollar that has come into the ward's account and every dollar that's spent from the ward's account. So this is an ongoing obligation. Don't powers of attorney and a little advanced planning seem like a better option? This is why advanced planning is key, because the alternative breaks families both financially, stressfully, and in every possible way. It's something that you want to avoid if at all possible. So tell your loved ones, meet with their lawyer, talk to a pro bono service. If nothing else, in Texas, you can get power of attorney forms for free off the Health and Human Services website. They are not ideal, in my opinion. They don't account for a lot of circumstances that people find themselves in, but something is better than nothing. get these documents in place, talk to your family, make your wishes known to your loved ones, and have these documents in order and accessible to the people that need them. And so with that, it's about 10:45. I will stop talking and open up the floor to questions. I appreciate y'all's time and patience. And I will leave it to you guys now.
Thank you so much, Brennan. That was a great presentation. Okay, if you have questions that you would like to ask, you can either do that through the chat box. You can unmute your microphone if you're on Zoom. I see we have one person who has called in via their telephone. You can press *6 on your telephone and that will unmute it, and you can ask your questions at that time. So please go ahead and join in the conversation. Well, while people are thinking about that, Brendan, if I could ask, I have a friend that has Alzheimer's disease, and it's been quite challenging for her family because there's no one at this point in time that is saying she's incapacitated. She's obviously affected in many ways. So do you see that as being a common problem where there is no one that will step up as far as a physician and say she's incapacitated?
I see that a lot. And one of the things to note, again, this is Texas specific, but legal capacity is different than medical capacity. Someone may be medically incapacitated, but have legal capacity to enter into documents. In Texas, the test is, do they know what they have? Can they tell me I have a house and I have an IRA? And can they tell me their family situation? Can they tell me I'm married and I have 3 kids? I work with clients that are in the early stages of Alzheimer's all the time. And as long as they have legal capacity, we can get these documents done and these things in place to avoid the need for guardianship.
Well, the situation in her situation is she's probably got 5 wills and sets of legal documents to different people. So when something does indeed happen to her, it's going to be messy.
Oh, yes, ma'am. I hate to hear that.
Yeah, but
Fortunately, it's not uncommon.
Yeah, right. Ashley, did you have a question? I see your hand is up.
I did. So I'm actually in the state of Michigan and my mom has Alzheimer's. And we have durable power of attorney for financial. And when we got that in place, they told us through our local hospital to do like a 5 wishes program for medical. And recently I've been told that the medical for the 5 wishes is they're doing away with it, and to get a medical power of attorney through a lawyer. However, I already have my letters from the doctor stating that she's incapacitated. The financial power of attorney has taken place, and the lawyers now won't create a document for the medical. I guess I don't know really what to do at this point.
What I would do is talk to a lawyer about what happens if there is no medical power of attorney, because there is, I feel certain, a law in Michigan that says if there is no power of attorney, who speaks on the patient's behalf? And again, it may be the spouse first, it may be the child first, it may be the closest adult child that's nearest the patient. I'm not sure, but I suspect strongly that there is a law that will say if mom can no longer make these kinds of decisions and there is nothing in place, who is going to be that person? And it's better to know in advance than to find out when emergency strikes.
For sure. Thank you.
Mm-hmm.
Thank you, Ashley. Glad you asked that question. Others may have that same situation. Shane asked over here in the chat box, my mom's durable power of attorney has a section that allowed for her to initial areas to give financial powers to the agent as well. Is that enough to have?
That is, Shane, I don't know if you're in Texas, but Texas's durable power of attorney has a lot of boxes to check or blanks to fill in an initial. You do want those initialed, but it can't just be initialed. It still needs to be signed and notarized. So as long as it's filled in correctly, as long as those initials are in the boxes that your mom wants, and it's signed and notarized, then yes, it should be good enough to have for finances.
Yes, he's in Texas. Yes, a lot of boxes were checked, signed, and notarized. So sounds like
That's a good thing. Like I say, with a financial power of attorney, I try to encourage my clients to make it as broad as possible. Because if you limit it to certain things, banks are much more likely to have questions and be more careful about what they let someone do. And so with a financial power of attorney, we don't want a bunch of hurdles in our path. We want to appoint someone that we trust fully and give them full authorization. So it sounds like your mom's in good shape.
Thank you so much, Shane, for asking that question. Another thing I hear a lot, Brennan, is people are, after someone has died, they have a will. Are all wills probated or only certain wills?
All wills are probated if there are assets that need to be transferred. So probate is primarily concerned with what's called legal title to things. So like your house, there's a deed recorded that says Glenda owns this house. Nobody can just move in and take over, right? Well, after you die, there has to be some process to transfer that legal title to someone else. And so that's what probate is. But if mom lives in an apartment and she's designated beneficiaries on all of her financial accounts, things like her couches aren't registered anywhere. There's no legal title that needs to be transferred. So there may not be a need for probate in every situation. But usually if there's land, a house, real property involved, probate is going to be necessary unless they've done a living trust or something to specifically avoid the need for probate.
Thank you for that answer because it's asked a lot. Okay, Nicole says, do you know the standard for becoming a Social Security representative payee? Curious if it could be an option for having more control over money, even if the person is not meeting the criteria required for guardianship under state law.
So Social Security is a federal program, of course. Texas powers of attorney, the powers of attorney in any state really, are a state-specific document. And so Social Security office does not accept state powers of attorney. They require someone to go through the representative payee process. So it is kind of like obtaining power of attorney through the Social Security office. They have their own protocols and procedures that you have to go through. Usually there has to be at least some showing that the person whose Social Security it is can't manage their finances on their own. Sometimes if that person is just having trouble with it, they can join in and say, look, you know, I've just got diagnosed with Alzheimer's. I still have my wits about me, but I want to make sure that my daughter can handle my Social Security if and when I get to the point that I no longer can. As far as an option for having more control over money, it is, but once that money gets deposited into the bank account, that's when the bank is going to say, we need to see the power of attorney.
Nicole, thanks for asking that. I just set this up for representative pay for my daughter for my Social Security last week. So it was interesting that she had asked that question right now, but I'm perfectly fine. It's just in the future if it's needed. Ella says, does the home automatically go to the children? I'm assuming she's saying if there is not a will in place.
No, ma'am, it has to go through probate. Nothing happens automatically as far as houses. There are multiple ways to pass a home. You can put it in a living trust. You can designate it as part of your will, but that will have to be probated before anything can take effect. Or in Texas and a lot of other states, there are what are called transfer on death deeds that allow you to designate someone who will take over the property at your death. And if that deed is filed while you're still alive, then and only then will the property pass automatically. But that's the only situation, and it again involves advanced planning. If there's no planning done, nothing is going to be automatic.
Oh, Good information, Ella. Sounds like you need to be taking some other steps there. Anyone else have a question or a comment? We have a few minutes left, plenty of time. No, I don't see that anybody has another question. That's because you did such a great presentation, Brennan.
All right. Well, I'll take it as a compliment then. All right.
Okay.
Well, thank
Absolutely.
you for having me, Glenda. I really appreciate this opportunity, and thank you all for being here and listening. And I hope this was helpful.
Oh, thank you. Remember that if you register for the call, you will receive the PowerPoint presentation. Oh, let's see, let me see what over here. Oh, lots of thank yous for the presentation. So that's great. As I was saying, you will receive the presentation via email. So watch for that. If you did not register for the session today and you would like a copy of the presentation, you can get in touch with our customer service representative. And that number is toll free at 866-390-6491. Okay, let's see. So Ella says, can transfer of death deed to more than one person?
Yes. I don't think it's necessarily ideal because, again, if you give a house to 5 kids, when it's time to sell that house, the title company is going to require every one of the 5 to sign off. And in my experience, getting 5 people to agree to anything is difficult, especially after a loved one has just passed away. So I would explore other alternatives, but it is possible. Yes.
Oh, good. Good question, Ellen. Great question. Well, okay. Let's make sure that no one else has anything to say, and they're saying thanks again. So, Brendan, it's been my pleasure to be with you today, and thank you everyone for joining us. I hope that you got a lot of great information. I did. It reinforced some things I already have in place. So that's good for me, and I hope it was good for you. So thank you very much, and I hope to see all of you on a future session of the Caregiver Teleconnection. Bye-bye.